Good evening. This is John Milburn for Laws 11057 Introduction to Law. This is week number 6. It's the 22nd of December 2016, and this week we're dealing with issues to do with communication, collaboration and self-management. However, we are in a little bit of catch-up mode in that I want to also deal with legal thinking, which was the topic for week 5. We have many outstanding matters to deal with. One thing I earmarked last week is that at some stage I want to do a redrafting exercise. Another is that typically I'll do what we call a brainstorming exercise, and I'll introduce that tonight. We won't do it tonight, but it's something that I like to do later in the course if we can. And of course, I do want to review the problems, the weekly problems. Now, we don't have many on the line tonight. Thanks for those of you who are joining us live. The same rules apply about whether you're happy to be on camera or not. I'll just put myself on speaker view for a moment. But do feel free to unmute your microphone, ask a question, use the chat facility, and if you're there on live, we'd like to see you as well if you wish. So another thing that we want to do is go through the weekly problems. I'll do that when we have more people and we have more responses. So the first thing from tonight is this. If you haven't provided a response to the weekly problems, please do so. So I'm very grateful for the people that are contributing. Each week we tend to see the same names. So just to be fair, to ensure everybody's doing their work, please get in and do those weekly problems. So in the new year, we'll start to go through those and we'll catch up. We'll probably start back at even week 2. So from week 2 onwards, make sure you've got an answer to each of those problems and contribute. That's one of the few places where we do ask you to put material directly into Moodle. The rest is on you, crew, apart from assignments, of course. All right, so before we start tonight's session, are there any questions to kick us off? Anyone have any questions? I'll just go to gallery view for a moment. No? Okay. All right. Thank you very much again for your assessments for the first assessment. And the second one is now due. The Legal Problem Solving Toolkit on Thursday the 19th of January. So for those of you also doing statutory interpretation, that statutory interpretation assignment is due before the next Introduction to Law assignment. All right, so tonight we're talking about a number of different things, and I want to talk about legal thinking. I'm going to kick off with an exercise for those that are joining us live, and it's simply this. Let's assume that you're a practicing lawyer. Let's assume that you're consulted by someone who's involved in a neighbourhood dispute and you have to give advice in relation to tree issues. You're really stuck and you're in a mediation and the mediator is trying to find a way forward for the participants. So one party says, I am really annoyed at the damage which your trees are causing to the fence, and the other neighbour says exactly the same thing. And neither party are willing to talk to each other. Can you think of some ways, and I'm asking you to think laterally now, are there some ways, some ideas that you can come up with to encourage the parties to think about this issue and treat it as a common problem? There's a bit of a hint.
Would it be mediation?
Yes. Okay, so let's assume we're in a mediation session and the parties are just at a deadlock. How do we deal with that issue? What are some suggestions? So thanks, Shay.
John, can you hear me all right? It's Alan.
Yes, Alan. Here. Yep, we can hear you.
On the screen, there's a code number, JC16639, but it's actually me. I'm glad that...
thanks, Alan. No, we can see you.
Good. You would probably back off and offer to find common ground between the two parties. What is it that they agree on?
Exactly. I think that's always a good standby. So if you're really stuck, start to think about points of agreement. So what are the thoughts of things that, as a mediator, you might suggest to the parties is a way of coming to some agreement? I'm asking you to think laterally now.
In the kind of situation you suggested, John, there's bound to be common dislike of council regulations.
Exactly. Find a common enemy is a way of bonding people. Yep, that's a fair enough comment. Are there other things that you can do to encourage the parties to come together and make an agreement? All right. We do have a small group tonight, so I'm very conscious of that. Look, one thing that I do as a mediator, in terms of the context of thinking laterally, is I might pose a hypothetical. So I may say to the parties, for example, in an open forum, look, if you had a good amount of cash, which you don't have, let's say, but let's say you did. Let's say I gave you $20,000, but the specific condition was that you must do something to deal with that area on your side of the property, the common fence line, and the neighbour's property. If the neighbour said, I don't care, just do whatever you want, how would you spend that money? And they might then think about positive ways that they would spend the money. And I pose the question to the other side, and it's surprising how often the parties are actually thinking along the same lines, but they just haven't communicated that to each other. So I really like Alan's idea. Try and bind the parties by picking on, if that's the right term, a common enemy. Or another way is thinking laterally. You think about a hypothetical situation and then try to apply it in a real life situation. So when you're practicing law, what I'm really getting to is this. It's not just a matter of identifying what the legal problem is and applying it to the facts. Sometimes you have to think laterally. You have to think much more broadly. And I like to think of it in terms of brainstorming. And we'll do some brainstorming exercises later in the course. So this is all part of Chapter 8 of your text, which is dealing with thinking skills, and it's an introduction to legal logic as well as legal writing. Now, when it comes to legal logic, when you're answering a question for an assignment or dealing with a real-life legal issue, we have some basic platforms, some tools that you can use to guide you through that process. Now, can anyone tell me what these things are? And I'll mention some acronyms now. You can tell me any of them or your favourite. There's the IRAC method, IRAC. There's the MIRAC, MIRAC. The CIRAC, CIRAC, to name a few. There are others. The MIRAT method is another one. So what are these acronyms? What do they mean in practice? Does anyone like to offer an opinion? Feel free to unmute your microphone.
The process of how you're going to answer it, because I use the IRAC when I'm doing the assignments anyway. I always find to structure the assignments in this sort of way helps me to have like some sort of a template to work on.
Yep, thank you, Shay. So it provides you with a platform, a framework within which you can use. So what does IRAC mean?
The introduction. Is it introduction? I can't even remember now. It's the issue, then the rule, application, and conclusion.
That's very good. Grace, do you have any thoughts? Thank you, Shay. Sorry, I thought I saw you unmute your microphone there, Grace. All right, so that's spot on, Shay. Thank you very much. What is MIRAC? What does that mean? This is probably the one I like to use, but it's personal choice. MIRAC. I'll give you a hint. The last four letters are the same as IRAC. What's the M stand for? We're being
material fact.
Who was that? Sorry?
Sharon.
Yep, spot on. Thank you, Sharon. That's it. Material facts. So I like to identify the material facts as the starting point for my answer. Sometimes people use CIRAC. What is CIRAC? I'll give you a hint. The last four are the same. What's the first C?
Alan here, John. You start with the conclusion in CIRAC. then the issue, the rules, application, and then you revisit the conclusion to see if there's some adjustments to be made.
Spot on.
I like this one.
Yep, that's a very good one. And can I tell you from a practical perspective, I often use CIRAC or a version of CIRAC when I'm making a submission in court on a penalty that might be imposed on a plea of guilty. So when I stand up to address a magistrate or a judge, I may actually start with my conclusion. So I may say that in relation to this matter, my submission is that an appropriate penalty is a term of imprisonment made subject to the imposition of parole after a period of 6 months imprisonment or something along those lines. The reason I do that is the court then knows exactly what I'm trying to work towards. They're not waiting, as if they're holding their breath, waiting for me to say, what am I trying to do? I'm saying at the outset, this is what I think is appropriate. This is what I think respectfully you ought to do. And now I will tell you about the material facts, the issues, the rules, and the way I'm going to apply it. And then I'll come back to my conclusion. So CIRAC works, a version of CIRAC works in the context of a criminal law submission. So keep that in mind.
Can I just jump in?
Yes, Shay?
I actually thought that structure was just for legal writing. I didn't realise that's how you use it in the practical sense.
Look,
oh my god!
It's a way of it's a way of thinking about law and legal principles. And every time you might be with a client providing advice, and in your mind you're going through IRAC or CIRAC or MIRAT. Or a combination of those things. So it's providing that structure. So what we're really talking about tonight is the process of legal logic, which is associated with legal writing, but also the application of legal principles generally. And quite often you might have a version of this that suits you. You might say, look, I want all of this. I want CMRIC. I want the conclusion. Then I want to talk about the material facts. Then I'll talk about the issue, the rule, the application, and then I'll revisit the conclusion. So there's no one rule that says you must do something in particular. All right, now let's see if we can apply that. You should all have your textbook with you. I hope you do. Do we? Yes, maybe. Have a look at page 269. It's excellent for thinking through the issues. And you have probably read this, but I'm going to ask you to look at this as we go and provide me with your opinion. So at the bottom of the page, you see some commentary in relation to a factual scenario and a dispute. So the dispute relates to the university student attending the bar. So you can see that at the top of near the top of the page. So just read that factual dispute.
I don't have the book on me. I'm so sorry. I've left it at my parents' house.
No, that's all right, Shay. All right. Anyone else not have the book? All right. You might just have to follow along, Shay. So just have a read of that factual scenario.
John, is this Gaia is a university student?
That's the one. Gaia is a university student. One evening she attends a bar owned by Kevin. So just read that paragraph. Exercise your speed reading skills. All right, time's up. Hopefully we got there. Just out of interest, can I just get you to show me your version of the page? You'll see mine, there's lots of yellow there. I'm looking for yellow bits. Lots of them are okay. I think Sharon's is not marked. Sharon? All right.
I don't like to mark my books.
I'm not saying that I'm not saying in law you must use yellow highlighter, but I'm just saying that's something that works for me. Oh,
that's what I do.
What was that, Sharon?
This is what I do. I've been taught never to write on a book, so I do yellow post-it notes. So that's my highlight.
That works as well. Oh, I desecrate my books.
Well, this one is actually second hand, so the guy that had it before me does. But the yellow pages, the yellow are mine.
Okay, so we all have our own techniques for doing that. Now, when you're in practice, or if you go to a community legal service and you're assisting a solicitor who's providing advice, here's what taking instructions from a client often sounds like. Dribble, 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 gem, dribble, 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 gem, dribble, dribble, dribble. Do you get the point? Your task is to identify the gems in amongst all of that dribble, because clients really, it's surprising, but maybe it's just that the legal training, but they really don't get the important points or the material facts. So the point of this exercise is for you to identify what is actually important in this critique. Now, the answer, of course, is at the bottom of the page. So the material facts are that Gia was a patron at the club. Another patron, Jay, dived onto Gia. Silent Bob, the bouncer employed by Kevin, did not prevent Jay from climbing onto the stage. Gia was physically injured, her phone was damaged, and it's common practice for security staff in bars to allow patrons to stage dive. So that's what's really important. If you had an ideal client, they'd come in and just tell you those sorts of things. So there's a lot of other things that really aren't that important. They may be important not for liability, but for quantum, the fact that she's a university student, or he or she, but that's not really important as far as liability is concerned. Do you understand what I mean by liability and quantum?
Not liability.
Or quantum, please, John.
I don't know what quantum.
We know what or means, though, so we've got that part right. All right, so quantum, so liability means who is liable for a certain action and to what degree. So in the context of this factual scenario, when lawyers talk about liability, they're really trying to determine whether, in this instance, Kevin is liable for the loss suffered by Gia. So we call that question as to whether Kevin has to accept some responsibility, if not all of the responsibility. We call that liability. Quantum talks about the dollar amount. So in this type of case, it's in two parts. So we argue about liability. And if
is that quantum like as in quantum physics? The same sort of, is that spelled the same or?
Yes.
Yep. Yeah.
Okay. My limited ability in quantum physics, I think so, yes. So quantum means amount. So quantum is the dollar figure. So if a court found that Kevin was in fact liable to Gia, that's the issue of liability determined. We then go to the next phase to determine, all right, what's the dollar figure of damages or compensation? That's what we call quantum. Okay, but thank you. Sometimes, you just do this so often, sometimes you gloss over things, so thanks for stopping me there. All right, so the point of that exercise was for you to start to think about the things that are really important. Okay, apologies to Shay, but I'm now going to ask you to go over the page and have a look at the example on page 270. Here we don't have the answers. So this is the issue with Catherine shopping for groceries at her local supermarket. So speed read that one for me if you would. Okay. Time's up. Before we talk about Catherine, I just want to go back to Kevin and Gia and just mention that when you're considering the issue of liability, bear in mind that you may have to think about more than one area of legal practice. It may be that Kevin could be liable in contract law or torts law or consumer law or company law, and there might be issues of primary liability and vicarious liability, meaning his liability for the actions of Silent Bob, his employee. So just bear in mind that liability can be multi-layered within that context. All right, let's go back to Catherine. Catherine's at the supermarket. Tell me, what are some of the material facts here? Can we go around the room for that purpose? Now, a couple of people...
Catherine sees an avocado on sale and she decides she wants it because she's cooking Mexican, but then she realizes she's actually got 3 avocados at home, so she decides to put it back on the shelf, but then a employee approaches her and says that she can't do that. She's actually already, bound to that contract for the avocado. Yeah,
look, I think you've put in too many matters there that are not material. So I just want to break that down. So tell me the one material fact. So
he had a little squeeze of the avocado.
Gently squeezed it.
He gently squeezed it, but I think all the irrelevant facts is the first part that she's cooking Mexican that's irrelevant. It's the fact that she picked it up and she squeezed it.
I agree with that.
That's the only thing that I think she could really be. It's the same as if you drop something and you break it. Some people would make you pay for it. So it's kind of like she squeezed the avocado, potentially bruised it. Yeah.
Okay. So you think that selecting it and squeezing it is relevant? But
I just want to say that people always pick up numerous avocados, squeeze them, and they're not right, so they put it back and
No, that's fair enough. Alan, oh, sorry, Shay. Just Alan first, if I may.
I think placing it in the basket is crucial.
Yes, I agree with that as well. Thank you, Alan. Yes, Shay.
Would it be her intention to purchase it?
Well, do you think her intention is relevant? Is that a material fact?
I was just trying to... Sorry, I didn't read it because I don't have the book.
No, you're right.
Her intention to create legal relations would be a fact, but I think because in a shop it's just an invitation to treat, I'm not sure, but I don't know if the person's actually made the offer until they've actually accepted the offer until they've paid for it in that circumstance.
Yeah. Look, I think here's what I say is relevant. I think that Catherine's shopping at the supermarket is relevant. She's there, so that's a relevant fact. I think that, was it Dakota and Alan primarily said the fact that she selected the avocado, gently squeezed it, and then, as Alan said, placed it in the basket. I think that's material. I also think that it's material that she attempted to return the avocado and is stopped by the store manager. So if we're talking about the legal arguments, to my mind, they're the material facts. Now, if I'm right, I'm not saying I'm necessarily right, but if I'm right, can you tell me, therefore, what is not relevant to this situation? And poor Shay doesn't have the book, so it's very hard.
That it was for her to make guacamole.
Yep, I agree. Who cares? Yep, I agree with that. What else is irrelevant?
That it was Saturday morning and they only cost $1.
Yep, absolutely. I agree with that. Doesn't matter. What else is irrelevant?
That she looked for corn chips.
Yep, doesn't matter. Who cares? So we're using the who cares test in the legal context. Yep. What else is irrelevant?
The fact that she already had some.
Yep, the fact that she's got 3. We don't care if she's got 1, 3 or 30 in the fridge at home. Doesn't matter. Not relevant to this case. All right, so that's really good answers. So thank you very much for that. So what's the legal issue here? I mean, is anyone doing contract law or done some contract law?
The legal issue is when she actually accepts makes an offer to buy the avocado, and
Okay.
what stage that is at,
Yep.
whether it's before she pays or when she pays.
Yep. So it's the issue of whether it's an offer which is capable of making a contract or an invitation to treat. So there's a bit of contract law in there. Okay. So thank you very much for participating in that exercise. Anyone got any questions about that?
Sorry, can you please just tell me the answer, because I'm a bit unsure whether when there's an invitation to treat in a shop, if the person actually has to pay for it to accept the contract, or it just depends. No, they don't.
No, they
put it in
don't.
their basket.
No.
So once it's in your basket, it's binding.
No.
Okay.
Nope.
Once you pay for it, it's binding.
Yeah, once you go and offer to pay for it,
Oh,
and
once
they
you're at the
accept that
counter,
offer for you,
Yeah.
that you wish to buy it, then it's binding.
I see. Cool.
I
Thank you.
suppose she's outside, but I'll just quietly tell you a little story about my wife on one occasion. This is many years ago. We were at a duty-free store, and there were a range of watches that were on display, and they were all, it was overseas. I think that was like £160 or something each one, but one of them was £60. But it kind of, you could tell that it was a mistake, and my wife said, "I'll have that watch," pointing the one that was at £60, and they're about to ring it up on the machine. Then they stopped and said, "No, this doesn't look right. Better check it." And then there was a little legal argument that went on, and I was on the sideline about the nature of the offer. You know, you've made an offer to me, I've accepted it, you're bound by it. And in the end, of course, that wasn't the case. So it was merely an invitation to treat, the advertisement. So when goods are displayed for sale, that's actually an invitation to treat. It's not an offer.
I always thought exactly what your wife thought up until I did this course. I truly
I.
around. Yeah.
Yeah. Look, it's compounded a little bit. You know how I mentioned before about Kevin, that you've got to think about different areas of law? It's the same sort of thing here. I'm talking contract law, but consumer law may be a different kettle of fish. So you've got to be really careful about giving a definitive answer, because there may be other areas of law that have an effect on this.
Were you giving legal advice, John?
No, I wasn't. I was staying out of it. All right.
Sorry, John. So were you saying that your wife saw a watch for one price and they tried to say, "Oh, sorry, that's been put in the wrong spot"?
That's exactly what happened. In the end, I think she paid £160 for it anyway. So it all worked out fine.
So weren't they going to give it to her for that price?
They were originally, and then they thought, no, I better just check this. It doesn't quite look right. And then came back and said, no, that's a different price. So that's what it was.
Mm-hmm. Yeah.
All right. Now, deductive reasoning. You would have read that in your textbook. I'm just going to give a summary of this. So see if you can follow this and maybe apply it. Deductive reasoning. All x's are y. So think about that. All x's are y. This z is x. Therefore, z equals y. All right, so that's deductive reasoning. Put it in a different way. All dogs, x, are mammals, y. This animal, z, is a dog, x. Therefore, this animal, z, is a mammal, y. That's pretty quick, but did you follow that? Those of you who've studied logic have a big advantage when it comes to this part.
What's studying logic?
People,
Is there a course? Can you study logic in law?
No.
Oh, okay.
No,
not in law. Just in general.
This bit tonight is the extent of the discussion on logic per se.
Oh, okay, cool.
But
I think I've answered these. Oh, sorry. Go on. Were you going to say something more about logic?
No. Please.
Okay, that's cool. I answered this as a question. Is this the accident, the sweeping generalization?
Yes. And
Yeah.
we'll go back and talk about those specific matters later. But you're right.
Yeah.
So the idea of logic is that you think about the way in which you put arguments together so that they are logical. Yes, Sharon?
Sorry, where can you do a course in that? I'd love to do something like that.
Yeah.
Because that's what I fall down on.
Yeah, no, there are certainly logic subjects within the context of, say, arts degree courses, I think. Alan, are you aware of any logic courses or units?
Look, not off the top of my head, John. No, but you probably find something similar to it in mathematics and algebra.
Yes, I'm sure. So, yeah, there are definitely logic subjects, like Introduction to Law. You know, there'll be Introduction to Logic or something.
I'll have to go and find one.
Worthwhile doing. All right, so that was deductive reasoning. Then, of course, we have inductive reasoning. Can anyone tell me what inductive reasoning is? It's not a deduction.
I'm guessing it's where you add in all sort of elements and they're not necessarily relevant to...
Yeah, but not the answer I was looking for, but yes. Yes, Alan?
You assemble facts and you look for patterns in those facts that are repeatable, and then you come to a conclusion about what might be leading to those patterns.
Yes.
So could it be about the subject matter?
What was that, Shay?
Like about the subject matter?
Yes.
Like if it's about one particular matter and it's like a repetitive matter?
That's it, yeah. I like Alan's explanation, but I'll probably put it this way. When we're talking about inductive reasoning, we're really putting ourselves in a position where we can make a prediction based on experience. So that is inductive reasoning. The reason that we do this is that when you're standing in front of a court or you're arguing a case or you're promoting a particular position, you need to be able to support your argument with some degree of logic. There's got to be some basis for it. What's reasoning by analogy? Yes, Alan?
If you construct a picture of a situation that is that has the same shape, the same structure as the situation you want to convey the content of, you make comparisons on the basis of the similarity between the two.
That's it. Yes. So you're arguing that a certain thing is analogous to another thing, and therefore, by analogy, one will take on the characteristic of the other. So it's very common that we use that argument. You've got to be a little careful because it is easy to think that you're reasoning by analogy, but you're actually falling into the trap of arguing based on faulty reasoning, such as reverse accident or hasty generalization. So what you might think is an analogy could in fact be a hasty generalization. So just watch those two and have a read of those carefully. So there are the exercises that relate to faulty reasoning. I've mentioned a couple of them there, but the others are sweeping generalization, there's hasty generalization, attacking the person, appeal to authority, appeal to majority, straw man argument, and irrational correlation and causation. What we might do is come back to those at a later time, although just touch on one of them, attacking the person. So just because a bad person has a trait or characteristic, that does not necessarily mean that a bad person will always have a certain trait or characteristic. Has anyone ever heard of a thing called phrenology?
Is it about frowning down on someone and attacking them?
No. Yeah, I'm working off memory here, not my notes, but probably 100 years ago this was discounted. But phrenologists used to consider the outline of skulls and from that determine whether a person was bad or not based on the shape of their bones. Of course, and that was all really just attacking the person or sweeping generalisation. Okay, so critical thinking. When you're thinking about something, think about whether your argument is reasonable and how do you determine objectively whether your argument is reasonable? What are the sorts of things that you need to have in support to justify the fact that your argument is reasonable?
Facts, relevant facts and materials.
Relevant facts and materials, yes.
And evidence?
Evidence, yes. Okay, good.
In some cases, witnesses. I don't know.
Yes, witnesses, which is part of your evidence. Yes, absolutely. What else?
What about the interpretation of the law that it coincides with? Like what's your argument if it's valid law?
So you can argue that it's based on statute or common law.
Yeah, and then follow the principles of the law?
Yep, through analogy perhaps. You can argue that your position, your argument is reasonable based on what textbooks and leading writers have to say as well. That can be a very powerful one. I used that one in court where I specifically referred to a passage from a text from leading authors, and the court really thought about that very carefully. When my opponent attempted to argue against it, it then became an argument of that lawyer against the authors of the text. Very powerful ally to have authors of a text if you quote from a section of a leading textbook. Of course.
But what kind of textbook are you referring to? It's
like I've got hundreds of textbooks, but this one happened to be a property law textbook. It was to do with an argument about instalment contracts. You'll have the joy of listening to someone about instalment contracts down the track. Okay.
Yeah, right.
All right, so when you're promoting an argument, I guess the point I'm trying to make here is, even if you have a list of the things that you base your argument upon, so that if you're challenged, you have got this thing that you can put forward. Ask yourself whether it's reliable evidence. Ask yourself whether you've come to assumptions. It's really easy and a mistake to argue based on certain assumptions that actually come to be false. So when you mount an argument, ask yourself, even on a checklist, have I assumed something here? If not, or if I have, is it a valid assumption? Can your argument be supported objectively, which is the evidence aspect of it? Is it based on justice and fairness? And I like this one. At page 289, if you've got your textbook, there's a quote that I think we should have a look at, because it does sum up the role of a lawyer pretty well. So page 289. Yeah, here it is. It's about halfway down. It's just below the think column. And again, it's got yellow highlighting on it in my book. And it says, importantly, perhaps paradoxically, critical thinking is an act of thoughtful disobedience rather than thoughtless or automatic disobedience. So critical thinking is thoughtful disobedience. What does the author mean by that? Isn't that a bad thing to do?
No, to be able to dissect what you're thinking, like to criticize your own thoughts, to be able to get some sort of factual, like to ensure that it's factual, perhaps?
Mm-hmm. Yep.
Or is it maybe to understand both sides of the story, maybe? So if you're trying to say that they haven't done the wrong thing, that your client's done the right thing, but you're trying to put yourself in the person who disobeyed the rules shoes, is it maybe? I don't know.
Yes, maybe that's part of it.
You're thinking as if you did it wrong, even though you mightn't have. Maybe.
Yep, no, that's true. So what else is meant by thoughtful disobedience as a positive thing? Why should
I suppose if you can back it up with, as you said, like intellectual material, and you can prove what, like your belief is with intrinsic and extrinsic material, well, then you've actually earned the right to go against the rules.
Yep. Is it your obligation as a lawyer to be thoughtfully disobedient on occasions?
Yeah.
A couple of contexts here. There's the wider context where you might be thoughtfully disobedient, but also in the context of acting for an individual client, you may be thoughtfully disobedient. You see, in statutory interpretation, for those of you doing both subjects, we see this all the time. We see cases where on the face of the statute, it might say something, but we know that it's your job to be thoughtfully disobedient by considering the context and the purpose of the legislation and those wider issues, and challenge what's there if you believe that that's appropriate. So when we talk about being thoughtfully disobedient, we can sort of describe that on a micro basis or a macro basis, depending on whether you're acting for an individual client or a much wider issue. Anyway, I'll stop preaching. But the point is, do be prepared to challenge what's there, and in that sense, be thoughtfully disobedient. It's part of your job.
Well, I guess everything in law is sort of like a fight. So, well, you're sort of always fighting other people. So you kind of need to be disobedient against them in a way. Like,
yes, fight with a smile. Fight with a smile, and inner determines and hold your ground. Look, sometimes you must be thoughtfully disobedient, even in a courtroom. What do I mean by that?
There may be errors of fact you have to correct that authoritative people like the judge might have, or magistrate might have erred on.
Exactly. That's a really good example, and you're duty bound to step in. Where else may you be thoughtfully disobedient in a courtroom? What if you're appearing for someone who's in custody? Your task is to successfully apply for bail. Before you stand up, the magistrate says to you, not inclined to give this person bail, not with these serious charges. Should you be thoughtfully disobedient?
Yes, because, well, I guess you're obliged to fight for your clients. I don't know if you'd say rights if they haven't really got any rights there because the judge says no, but you're obliged to fight for your client in whatever way you can.
Look, I think it's, and when I mean but you're right, Grace, when I mean being thoughtfully disobedient in that context, what I mean is don't be prepared to meekly concede a point simply because the court in a position of authority has made a certain statement. It's your job, it's your responsibility to argue appropriately and ethically in advance of your client's case. And you may have to do that in the face of odds that you seem are insurmountable or unrealistic. Of course, you've got to balance that with arguing a case that is unarguable.
Yeah, that was my question. That's what I was just about to ask.
Sure.
So, John. Yeah, so if you're like going into with that bail sort of situation that you're talking about, and it is a serious case, and you believe that it is a serious case as well, do you go in there thinking of if, say, for example, you're going to know that the magistrate or the judge is going to say to you, this is way too serious to even grant bail. Can you hear me okay? Yeah?
Mm-hmm.
Do you go in already with your own reasons as to why bail should be granted. Do you know what I mean? Otherwise, if they say, if I went into a courtroom and the judge said these charges are so serious that I'm not even going to grant bail, right now I'll be like, oh my goodness, well, like what would I say? You're probably right. Do you know what I mean? Like, if even in my opinion, it could be right that the judge is saying that, and I might be thinking that, but I have the responsibility to attempt to get bail or bail conditions on behalf of my client.
That's right. Yep, exactly. But you will invariably be confronted by that real situation in practice where a statement is
What would
made.
you say? Do you know what I mean? Like, say, for example, like something serious, like in
A child sex abuse case.
Yeah, something that's really serious. What could you say? Like, if they say, bail is like, I'm not going to give bail for this. If for some sort of serious crime like that, and you think, well, you're actually not going to get bail, would you just tell your client, I don't think your chances are going to be successful, or do you just attempt it anyway? Do you have any sort of insight, or like, am I making sense?
It
Probably
does.
not.
Yep. Yes,
You
Grace.
probably attempt it. You probably would attempt it anyway. I did work experience at a law firm, and I read through one of the cases, and it was a child sex abuse case, and it was like made me feel sick. It was gross, but like they obviously still had to do everything for the client possible, even if they didn't believe in fighting for that person, but they were paying the law firm to do that for them. So, I mean, I guess I'm not saying that they did this, but like, I guess you could almost manipulate it. But yeah, I'm not really sure. Like,
or look for loopholes, possibly.
Yeah, I mean, obviously, then the courts are definitely not going to let the person just go. But you can, if you thought that was going to happen and you believed they actually did it, you could almost make them look.
You know what? Surely
that's a really like probably non-professional thing to say, but I'm just saying, like, maybe that happens.
Surely we'll be running out of loopholes by now.
Oh, there's always some fine distinctions to be made, but it is important that you understand your role here is not to make the decision. That's one thing. So if you have decided that the person is guilty and should be put in jail, then that's not necessarily doing the right thing by your client. It may be that you provide certain advice.
Can't you withdraw if you see they've lost faith in you? You can withdraw from being their lawyer if they have lost faith in you or something.
That's true, but everyone's entitled to representation. And of course, part of your role in putting forward submissions on a bail application is to ensure that the situation is balanced, because it may be that there are compelling reasons why your client should get bail. So you've got to be prepared to put up the counter argument and be wary of conceding too early, too quickly. Yes, Sharon?
So, John, what would you actually say in that situation?
So if someone, for example, is charged with a serious offence, I would, the first thing I'd do is ask myself and then query with, and present the Bail Act accordingly, where the presumption is. So the presumption in a civilised society, I might say, is that a person charged with an offence is entitled to bail. The legislation may say otherwise and may say that the person should not be denied bail unless you can establish that it's appropriate. But the general rule, the general proposition is that anyone that's charged is entitled to bail. I then argue that this is a matter that is not necessarily conceded as a plea of guilty or a finding of guilt. I might look at the allegations that the police have made available and indicate that it's based on circumstantial evidence, that it's not necessarily a strong case. I might argue that the matter is likely to take a long time. There are public perceptions of people being locked up. I might indicate that possibly any period of incarceration may go beyond what would be the reasonable or likely penalty in any event. Therefore, it's inappropriate to imprison a person beyond that period of time. I might argue that the client has a strong job, family ties, that there is otherwise good reason for them to be out of custody. It may be that they have a need for attending a psychologist or psychiatrist or some sort of health issue. So there are a whole range of things that you can put forward. And of course, what you do is you substantiate that with facts that you and material that you back up your claims.
That's so clever. I like it.
Oh, no. So we'll talk more about that later during the course. Okay, so we had better leave. Problem is that I just don't have enough time in these sessions, so we'll continue on later. I do want you to have a look at page 296, though, and the attributes of a legal practitioner. And ask yourself this: how can you improve on your skills in relation to those attributes? Have a look at the last one, persistence. We've been talking about persistence in the face of opposition, and you've got to steel yourself for all those things that are there. All right, well, I'd better stop the recording now so we're ready for statutory interpretation in about 5 minutes. Thank you for attending. Yes, Grace?
There's a contracts, the Tuesday night contracts tutorial was cancelled. Something happened with the system, so they've changed it to Thursday night at 7 o'clock. So now there's 2 overlapping.
Oh, okay. All right.
Yeah.
Well, we have a number of different channels in the law school, so hopefully they're not using my channel.
No.
They're on Blackboard. They're on Blackboard.
I don't know which one to go to. I'll probably just stick with stat.
Yes, sorry. What I can tell you about statutory interpretation tonight is that I'm going to cover pretty closely chapter 6 of the text. I'm anticipating we won't have that many people that we can do the exercises. So in the new year, we're going to go through the weekly exercises, the tutorials, and we'll do a big catch-up in both intro and statutory interpretation. So I hope that helps you with your decision, Grace.
Grace, was that contracts A or B?
Contracts A.
Okay.
Sorry, John.
Yes, Dakota?
Will we be having a Zoom next Thursday?
No. I'm glad you said that. No, we won't. So next Zoom session, 2 weeks, 5th of January from memory. Okay.
So will more things come available on Ucrew or Moodle for our assignment on intro?
Yes. Yeah. And if you have any questions,
I can't seem to find too much about what we've got to do
for intro. No, I think those of us tied up in both subjects, we're sort of in statutory interpretation mode at the moment.
Yeah, that's okay. I'm happy with that. I just wanted to make sure I'm not looking at the right thing. You know?
I just note took from the video that's on the. Did you see the video? The YouTube video?
Yeah. I'm gonna watch that tonight. I saw it just before this.
Yeah, I'm gonna take from that. I think.
Yeah.
They're really good videos.
I can talk to you about the that second assignment as well.
Oh, okay.
We'll see how light up John goes.
Great.
But lately, when John logs off, mine closes down lately. I don't know why. It never used to do that.
Yeah. Look, what I think I do is I end the meeting so that I can re-establish a new meeting for the sake of recording it when I come back to statutory interpretation. So when I log off, it probably will cancel it, but I'm not sure.
Okay.
All right. Thank you very much. All the best for those of you not joining us soon. Have a great Christmas break, and we'll see you in the new year. All the best. Bye.
See you guys. Merry Christmas.